Buying a home together is exciting, but when the co-owners aren't married, the legal protections and expectations are very different. And if the relationship changes, dividing the property can quickly become one of the most difficult and challenging financial decisions a person will ever have to make. Hi, I'm Christopher Charles, the managing partner at Provident Law and a state bar certified real estate specialist. I'm here today to talk about joint ownership disputes and how you can help unravel a joint ownership issue when it arises, and why, even better, it's so important to have a well-drafted joint tenancy agreement. Having this in place can help avoid a costly, stressful legal dispute down the road. If you or someone you know co-owns real estate or is thinking about doing so, you'll want to pay close attention and take notes as I walk you through some very important considerations and steps to help guide you along the way. In Arizona, it's become increasingly common for unmarried couples to purchase property together, or business partners or family members to own real estate together. So when we have a dispute that arises without a well-written agreement between the parties, that is a recipe for disaster. And if the parties can't effectively come to an agreement amicably, informally, then we're going to have to involve lawyers and the courts and go down the road of a partition action, where the court will compel the property to be sold, and then the judge will equitably distribute the proceeds from the sale based on each party's right of contribution, if any. In Arizona, when two or more people take title to a property, they typically take title as joint tenants with right of survivorship or as tenants in common. But relying on the deed isn't enough. The deed simply says who owns the property. The deed will not dictate any relationship between the parties' respective interests in the property. Instead, any joint ownership of real property should include a written agreement governing the relationship. Typically, this is referred to as a tenants in common agreement. But whatever we call it, there should be a well-drafted, thorough agreement negotiated and signed by the parties, spelling out what their expectations are, obligations, rights, and privileges are relative to the property. For example, this agreement should determine who is responsible for paying the carrying costs, including mortgage payments, property taxes, insurance, HOA payments, the closing costs, the brokerage commissions. How will the proceeds be distributed? All of these things can be discussed, negotiated, and then written and agreed to avoid any dispute from arising in the future. Now, sometimes memories fade and we just need to be reminded, oh yeah, this is how we agreed that the proceeds would be distributed. And whatever the agreement says, hopefully if we've got well-meaning joint owners together, that will resolve it then and there. Without a written agreement, co-owners of real property often make assumptions that just don't exist under Arizona law. For example, many people think that every dollar they put into the property, they're going to be entitled to get back. But that's just not how Arizona real estate partition works. Under Arizona law, each co-tenant is entitled to a right of contribution, but the right of contribution is generally defined as the increase in value to the property relative to improvements that were made. Now, of course, joint owners are also entitled to reimbursement for down payment, taxes, that type of thing. But when we're talking about repairs and improvements, modifications to the condition of the property, the law is pretty clear that the owner is entitled to the increase in value attributable to that improvement. Co-owning real estate with someone can be a great financial decision, but doing so without a written agreement can be a costly mistake. If you or someone you know owns real estate with another person or is thinking about doing so, call our office today to schedule a consultation. My team and I would be happy to provide excellent legal advice and counsel through the process to help you avoid mistakes and to help maximize your investment.